box. And Danny is coming around with them as well. So without any further ado, I am going to pass on to Jyoti Pandey from the Centre for Internet and Society, India, and she is going to give an overview of the Manila Principles. Thank you very much, Jyoti.
Thanks, Jeremy. Good afternoon. Well, good morning. So the Manila Principles were developed as a best practices guide for government, industry, and civil society to develop, to guide how regimes and frameworks for liability and the regulation of online intermediaries for online content is to guide these practices. The 6 principles are, and I'll just quickly read them before I get into the process and the background of how we actually develop the principles. So there are 6 principles, and each of the principles then subdivide into certain other nuances that need to be considered within each of the best practices that we've identified. The first principle is that intermediaries should be shielded by law from liability for third-party content. The second states that content must not be required to be restricted without an order by a judicial authority. The third principle states that requests for restrictions of content must be clear, unambiguous, and follow due process. We've then considered the tests of necessity and proportionality, and the fourth principle states that laws and content restriction orders need to comply with this test. The fifth principle considers again due process, and we have stated that laws and content restriction policies must follow due process. And the final principle considers transparency and accountability. Each principle, as I mentioned earlier, has subsidiary points that expand on the theme of each of the principles. And just giving you a brief background on how we developed this. So this is initially a civil society initiative, and we had Electronic Frontier Foundation, Article 19, and Center for Internet and Society that came together. We also then expanded, and we had Kitanet from Kenya, Derechos Digitales from Chile, ADC from Argentina, and OpenNet South Korea. And we had experts from and representatives from each of these organizations that came together and worked on an initial draft. This draft was then circulated to a larger audience of academics and people who have been engaging with these issues for very many years, and we got their feedback on how we can improve that draft. And after an extensive public consultation period, which ran both over mailing lists and at various internet governance venues, we finally launched at the Manila RightsCon meeting, as Jeremy mentioned. Yeah, I mean, in terms of diversity of the countries, another important aspect that informed our development of these principles was a jurisdictional analysis, where each of the organizations, the countries that they work in, we looked at the liability regimes that are applicable or in place, and we developed a set of criteria that would guide the issues and the best practices, helped us identify the best practices across each of those regimes. And there's a copy of the jurisdictional analysis along with the set of principles that are there in front of you. I'll just pass on. So I'm happy to answer any more questions on the process after the session. Thanks, Jeremy.
Thank you very much. You're ahead of time, so we're going to have more time for interaction, which is great. I'm going to hand on to Kelly Kim, who's going to talk about the advocacy and outreach activities that we've engaged in around the principles since they were first released. So, Kelly.
Can you turn the PowerPoint on? So our OpenNet Korea is an NGO fighting for digital rights in Korea, and my presentation will focus on our efforts for advocacy and outreach and research activities in Korea. So I'm Kelly from OpenNet Korea. I'm a general counsel. This is, I don't know whether any of you already visited, already visited the website. So this is a web page, and it is very great because the principles in like 9 languages. So you can also find like Korean version on the website. So this is very helpful in advocacy. So it is very important to make this information available in many languages if you want to have this principle on international impact. And so here are the 6 principles, and Jody already mentioned them. So now we see how Manila Principle can be applied to Korean notice and takedown regimes. So there are 6 principles. Oops, okay, I forgot to. So 6 principles, and then this is a like small table. So in Korea, we have Copyright Act, Article 103, and then Information and Communication Network Act, Article 44-2. So this is, there are printouts on your table, so you, which is titled a letter to the members of the parliament. So detailed information is in the handout, so you can just check the handout to see the provisions that I'm mentioning here. So there are like 6 principles, main principles. So first is and 6 principles, and the color shows like blue color means it complies with the principle. Orange color is like yellow color, like, so it's like it's dubious whether it's like in breach of the principle or not. And red colored columns are clearly in breach of the principle. So first, the principle says intermediaries should be shielded. So our Copyright Act gives like complete immunity to intermediaries, whereas our Information and Communication Network Act gives only partial immunity. So intermediaries are liable, can be held liable even if they take contents down. And second is like content restriction requires judicial order. So like in Copyright Act, intermediaries has no obligation. They only take down contents, when there is a request from copyright holders. So if it acts as a safe harbor. So if the intermediary takes down the contents, then it won't be held liable, and so it's like no obligation. But whereas Information Communication Network Act imposes intermediaries liability when it does not take the content down, and there's no court intervention here. So it's up to intermediaries to decide whether to take the contents down or not. And if they don't take down the content, even if the content is lawful, they can be held liable. And third is registration request. So our Copyright Act follows DMCA's notice and takedown very in detail. So it's okay, but like if you want to take down any contents under ICNA, you can just present any material supporting your argument. And fourth, test of necessity and proportionality. So when a copyright holder requests takedown of the content, the law says suspension. So there are rooms for other like technical measures, so like the intermediate don't need to delete the content itself. Intermediates can take other measures to suspend reproduction or transmission, whereas under ICNA, intermediaries must delete the content from the server. And temporary measures is also deletion. It only gives like 30 days blind period. And fifth is like laws, orders, practices should follow the process. So under Copyright Act, like notice and takedown of the MCA, the person who got their content taken down can request resumption of reproduction or transmission, whereas under ICNA, the one who posted the content has no right or no right to request resumption. And transparency and accountability, that's very ambitious goal. So they have nothing about like transparency or accountability. Okay, so how this was, so this is like detailed Provision of Information and Communication Network Act. So if any contents seems to intrude on other people's privacy or defames other persons or violate other person's right otherwise, it's very broad. So the person who make the request can just allege that this content has this problem, and then just request the intermediary to take the content down, and the intermediary must follow the request and just delete the content from just completely. So we thought this is a like huge problem and huge infringement on the Manila principles. So actually, Jeremy Malcolm visited Korea in July and helped us advocating against this provision by using this Manila principles. And this letter is what we circulated between our network and our people, so that they can help us change the law according to Manila principles. And we also brought this to Asia Pacific region IGF in Macau, which was held in June, and we got many signatures and many approvals of our letters. But still, it's going on. And we also proposed a bill with our members of parliament, and we are fighting to change the law. And Manila principle comes in very handy when we advocate to the people or to the MPs or our relevant multi-stakeholders that this law is against Manila principles and that we must change the law. Okay, and next is like filtering obligation. So Manila principles, rule 1A, is it A? Okay, rule 1 says that intermediaries should never be, intermediaries should not be required to monitor contents. So like we have, in Korea, we have many filtering obligations under law. So for example, like Copyright Act, Article 104 says, intermediaries must take necessary measures, such as technical measures. That means like monitoring and filtering of like copyright infringing materials. So it imposes such an obligation to intermediaries, and if the intermediaries does not follow, breach the law, it will be fined for like 30 million won, which is like $33,000 US dollars. And we also consider this a violation of Korea-EU FTA and violation of Manila principles. So we also proposed a bill to repeal the law according to Manila principles. And it's still pending at the parliament. And next is, we also have another law, which is Telecommunication Business Act, and it imposes filtering obligation for obscene materials. So it's different from copyrighted materials. Copyright works are very clear. They have right holders, and you can tell whether it's copyright work or not. But when you have to filter like obscene materials, it's very dubious. So the intermediaries must implement technical measures prescribed by presidential decree to filter those obscene materials. And those technical measures are like keyword filtering or any measures that can detect obscene materials by the title or its features. So it's like if the title of the material includes like sex or whatever, it should be filtered. So it's a very broad obligation. So it's also in violation of Manila Principles. And the intermediary can also be fined. Next is, this one is very serious obligation. This is another filtering obligation for child porns. Okay, of course, we should never ever allow intermediaries or anyone to like spread child porns, but this provision imposes obligation on intermediaries to filter those child pornography with the same technical measures like copyright materials or obscene materials like keyword filtering or any technical measure that can detect child porns, maybe DNA filtering or something. So, and there's no guideline. And if intermediaries violate this provision, it can be, even the intermediary can be imprisoned for 3 years or like fined for like 20 million won. Okay, it hasn't been used yet so far, but then, like this, okay, sorry, I'm sorry. So this month, as former CEO of Daum Kakao, he was indicted under that Article 17 because this KakaoTalk is most popular social network service, messaging service in Korea, and there were some people like sharing these child porns on their messaging app, and then the CEO was indicted for not properly filtering or preventing circulation of those child porns on this platform. So this was very serious. So we are the only organization advocating for the CEO, and like this is in Korean. This is a news article about this and Manila Principles. It mentions Jeremy Markham, and it also mentions our director K.S. Park, that like this indictment is against Manila Principles, and intermediaries should never be held liable for not detecting or not filtering child porns. And next is our research activities. So Manila Principles inspired network of centers online intermediate research project, which is, it says like good practice documents, and this was inspired by also Manila Principles. So you may go to the website and check the good practices out. It will be very helpful. Okay, thank you.
Oh, hello. Thank you very much, Kelly. And there's some other outreach that we may have a chance to talk about at the end of the session, such as in Europe, where, of course, there are moves to crack down on intermediaries or to impose additional responsibilities on them, which could impinge on freedom of expression and freedom of association online. So we may get to that if we have time at the end. But right now, I'm going to move on to Gabrielle from Article 19, who's going to talk about a new project under the auspices of the Manila Principles that we're extending our work in at the moment, and you can find out from her about how what that is and how to participate. Thanks, Gabrielle.
Thanks very much, Jeremy. I mean, first I'd like to explain why we think that it's important to have a template notice of content restriction. As you know, there are broadly 3 models for restricted content online. The first is a court-based model, whereby the intermediary is required to restrict access to content when ordered to do so by a court. The second model is also known as the safe harbor model, which is also the notice and takedown regime, whereby an intermediary must receive actual knowledge of illegal content and then take action to restrict it. And as we'll see, notice is particularly important in that particular context. And the third model is the notice and notice regime, whereby the intermediary is pretty much removed from the dispute about content, because the purpose of this regime is really to put the dispute back in the hands of the content producer and the person complaining about it. But the intermediary has an obligation to transfer the notice. So why then is notice important? It's because at least in the context of the safe harbor regime, notice and takedown, or the notice and notice regime, the notice itself can trigger exposure to liability. So this is why we decided to put together a new form on content restriction. Another important aspect of the notice regime is in relation to terms and conditions, because in addition to the legal requirements, intermediaries can restrict content on the basis of their terms of service. Most of the time, this can be done by either flagging content or pressing a report button and reporting. The concern here is that a lot of the time, individuals will just have to press the button and there'll be no explanation as to why there's a problem with the content itself. So the idea behind the form is to go through these different types of regimes and terms and conditions and design a template whereby individuals who want to complain about a particular piece of content must explain why they think it's problematic. When it is in relation to a legal issue, they would have to explain the legal basis, why they think, for example, that material is defamatory. In the context of terms and conditions, they would have to give more of an explanation as to why they think it's in breach of the intermediary's terms of service. So that's pretty much the approach we're taking at the moment in the template. The template itself is not yet publicly available. We're working on it, but it will be published soon, and we'll be seeking feedback. But I'll just end here by asking you to think about whether you think that putting together such a template is something that is useful, and what the best approach would be for dealing with it. Should we focus on all the different types of regimes, or should we design specific forms, for example, for the notice and notice regime, as opposed to notice and take down, or as opposed to, should we consider, for instance, should we have also a template when it comes to the court-based model? Since, in principle, the restriction needs to happen on the basis of the court order itself, nonetheless, would it be useful to have a particular template to at least alert the person complaining that nothing will be done until a court order has been received? So these are questions we'd like to throw at you, and we'll be consulting on this further on. Thank you.
So how can people get in further information from us if they're interested?
You can contact all of us, effectively. There's me at Article 19, Jeremy, OpenNet Korea, NCIS India, pretty much the founding, the members of the steering committee. And is there...
Yes, you can also go to our website, and there's a link to join up to a public mailing list if you wish to. So many ways for you to remain in touch and involved. Those were the introductory presentations, and now we're going to open up into a roundtable discussion with some friends and experts. We have Rebecca McKinnon, who's in the extended version of this table over there because she has to leave early, so she's hedging her bets and staying over there. Giancarlo Frozio, who's at the end. We have Nicolo Zangales, who's at the other end. We have Marcel Leonardi from Google, and they can tell us a little bit more about themselves as they give their remarks. And we're going to hopefully be able to jump around. Also, just checking, Eduardo Bertoni is not in the room, is he? No, okay, that's fine. So they're going to give a few remarks about either the associated work that they've been doing on intermediary liability or the impacts of the impacts of the Manila Principles on their work. So We're going to then, after that panel roundtable, we're then going to open up for questions and comments from the audience. So the rest of this session should be much more interactive than the first half. So since Rebecca has to go, I might start with her. If you have any comments, Rebecca?
One.
Gave it to you? No?
No, that's the one she gave.
Microfone aí. Microfone, tá ligado não?
Would you like to?
Yeah, it's working? Okay, so I'll let you go.
Okay. Thanks, and thanks for letting me kind of lurk on the edges here. My name's Rebecca McKinnon. I'm director of the Ranking Digital Rights Project, and we evaluated 16 companies, 8 internet companies, 8 telecommunications companies operating around the world on their policies and practices affecting freedom of expression and privacy of users. And our freedom of expression section overlaps particularly with Principle 6 of the Manila Principles on transparency and accountability. So I thought I would mention a few of the findings that I think are relevant and that might kind of help add some fodder to the broader discussion about transparency around requests in particular, and about laws and about practices. So in our section where we examined companies on indicators, asking questions about companies' policies and practices affecting users' freedom of expression, we had a question about whether companies disclose any information about their process for responding to third-party requests, be they from governments or private actors, including DMCA takedowns and whatnot. And out of the 16 companies, 8 companies publish some information to varying degrees about their practices and policies just for responding to requests, not including data about the requests themselves. And this included some but not all of the internet companies and a couple of the telcos, Vodafone and AT&T being the 2 telcos that disclose information. And then when it comes to reporting data about requests, we had one indicator asking about whether companies report data, in other words, numbers of government requests that they receive to take down or restrict content. Only 6 companies report any data numbers about the number of requests they receive from governments and courts. When it comes to private requests, there's even less transparency, so private requests in our kind of taxonomy, we include, notice and takedown in the private request, as well as people flagging content. And only 4 companies report any data about private requests that they receive. And in general, while there are quite a lot of places where laws are restricting or perhaps preventing companies from reporting about government requests, generally the laws are not preventing companies from reporting private requests, yet there's a lot less reporting on this, a lot less transparency about private requests. So this is something to flag and perhaps something that the Manila Principles Coalition might want to really push for intermediaries to do. And I would note, since we have our friend from Korea on the panel, and that OpenNet's been doing a lot of work in this area, that Kakao, the Korean company that she mentioned earlier, was one of the companies we included in our index, and they do in fact report on at least some private requests. So that's kind of worth noting. Another final note is that when it comes to enforcing terms of service, which would include enforcing, when companies are sort of their own initiative taking down content, including things like images they think are copyrighted, that, so anticipating that they will be held liable for this material and taking it down even if they don't receive requests. There is zero data, zero numbers reported by any of the companies studied on terms of service removals and restrictions that are done internally, not in response to requests, but just voluntarily by the companies. So that points to a real deficit in transparency, and that perhaps is preventing understanding of what's going on. And so I would recommend perhaps kind of trying to push for that. And of course, government transparency about this. And then one other point to make, then I'll hand it over to others, is that not very many companies are then posting sort of the content of requests onto third-party sites like Chilling Effects. It's really only a very tiny handful of companies that are doing that, basically 3 in our sample anyway. There's some other smaller companies that do it. But based on our understanding, in a number of jurisdictions, it's actually not legal for companies to use a mechanism like Chilling Effects to be transparent about the content of orders they're receiving. So that's another place perhaps for legal advocacy and push for legal reform, that when you have a lot of places, and I think Kelly can correct me if I'm wrong, I think Korea is one of them, where a Chilling Effects type site would not be possible because of the law, and that's a concern. So.
And have a good flight as you move off. So I'm going to hopefully not surprise him too much, but Marcel, I'm going to call on you because, of course, Google is one of the companies that does report its takedown notices that it receives to Chilling Effects, or Lumen databases, I think it's called now. But what about the other aspect that Rebecca mentioned about terms of service removals? Is that an area in which we can see some further disclosures by Google in the future? What do you think?
There has certainly been some progress internally discussing that kind of issue. Usually what happens when these private disclosures show up is they either involve very sensitive issues or they're a clear violation of the terms of service. So I guess there wasn't really a specific push to actually present that kind of data. So I'm really glad to hear now there's demand for that kind of transparency. In addition to that question, I think I would like to quickly highlight, I think Brazil is a very interesting case study on intermediary liability and how the Manila Principles have a very close dialogue with it. And the reason being is, for quite a while here, there was no specific immunity for intermediaries. So essentially, the legal system at first imposed strict liability on intermediaries, meaning that just because you offer an online service, essentially you would liable for whatever users were doing. After a few years, I would say maybe 4 or 5, courts start imposing how can I call this? A different standard of liability, especially like notice and takedown, but the problem is they adopted notice and takedown for any kind of content. So essentially you could claim defamation and then courts would say that intermediaries should have act upon that notice. And then if companies like Google didn't, what happened was that person would, for example, take the issue to a court, and the court would say, well, you should have known better. You should have acted upon the very first notice you got, so therefore you're liable from the very first notice that you got, not because a judge has analyzed the issue. So they tried to solve that situation in Marco Civil, and I think they did, just to some extent. Now it's completely compatible, in my view, with the Manila Principles, in which companies are actually required to, private parties or the government is actually required to obtain a court order to force companies to take content down, which is a very good sign of progress. There's still some stress, though, in to what extent that means. Essentially, on the identifiable aspect of what kind of content is. We get lots of lawsuits here in which, for example, we get very broad and generic court orders saying, please remove, I don't know, for example, the picture of this woman in a red dress. Please take down the video of the dancing bear or something, which is not exactly very helpful when you have so much content going on, especially on platforms like YouTube, who get like 400 hours of video per minute. So essentially, we have been trying to push that in the courts, explain that we need the URLs in order to take that kind of content down, but there's still some discussion whether they're necessary or not. I mean, recently we got some really good precedent on that. And finally, my final point would be, there's still lots of work to be done, especially now that Brazil is perceived as very, at least somewhat influential in these IG debates, and what we're perceiving is there's no dialogue with this community, with the local congresses across the region, and basically there's plenty of action to completely reform these recently enacted legislation. We are seeing plenty of people wanting to enact exceptions for these scenarios of intermediary liability, some of them pretty consistent with international practices, just for example, in the case of revenge porn. Notice and takedown system is in place, for example. But now everybody wants to create their own exceptions for the general rule. So we're seeing, for example, politicians across the region saying things like, yeah, offenses to politicians should be also in the fast track system. So that's obviously not a very good model.
Thank you, Marcel. I'll pass on to Nicolo in a minute, but first to reiterate what Jody said at the start, that this was a civil society initiative at the outset. We deliberately didn't decide to have a multi-stakeholder document on intermediary liability because we wanted to set a very high bar. But having said that, we are really gratified that many of the intermediaries have come out in support of the document, and for that reason we are also opening it up to endorsement by industry and by industry associations. And so we are hopeful that we're going to be able to announce some fairly high-profile endorsements from within the internet industry and the technical community to this document. So that's really good news, and you should stay tuned for more information about that soon. So, Nicolo.
Since we said that this was a bit more interactive, I thought I would jump in because Marcel was speaking precisely about principle 2 of the Manila Principle, whereby intermediaries cannot be required to restrict content unless an order has been issued by an independent and impartial judicial authority. So here, I think there is something to point out, that you can interpret this principle as referring to a property or to a liability rules. So for those who don't know the difference, it's a standard distinction made in law and economics, where property rules tries to secure the effectiveness of the protection of property. So it ensures that the owner has an effective mechanism to prevent anyone from interfering with its own default entitlement. That's what we call property. So in this case, the entitlement will be that the intermediaries should not be liable. And if we see this as a property rule, this means that it refers to any case in which a court or a complainant can force the intermediaries to remove content. Liability is broader, so it refers also to cases where the intermediary will be liable if he fails to remove content. So if you adopt this second perspective, you are not referring anymore simply to the need for judicial oversight and basically preventing the government from imposing a removal of content, but you are enshrining a safe harbor into the system where you say the intermediaries can do whatever it wants until it gets an order that says, okay, you have to remove content. Only at that point it will become liable. So I think on this, maybe some clarification could be perhaps interesting to make. And if we adopt the second perspective, that is liability, what we are talking about, so not only property but a liability rule, then we are going close to the standard that was adopted in Marco Civil. And I think this is very good. On the other hand, it should be pointed out that, as Marcel mentioned, the Marco Civil also identifies two specific exceptions. One is in the case of copyright enforcement, and the other one is revenge porn. So in this case, I mean, if we want to export it to the global level, maybe we should start thinking about how to identify the exceptions to these principles, because it's indeed particularly interesting. I didn't want to exhaust my intervention by this, because I'm This was a comment simply on the basis of a paper I'm working on, where I'm arguing that the Manila Principles can constitute one of the pillars for a global internet intermediary liability regime. I'll speak later about my other projects.
Much, yes, we'll come back to you after we've heard a few words from Giancarlo.
Hello, I'm Giancarlo, and I'm based at Stanford Law School, where we have launched, and as some of you may know, the World Intermediate Liability Map. This project showcases information about legislation, case law, and additional and pending bills and proposals connected to intermediate liability. And what I'm trying to do so is to access. So we are in a privileged through that project. We have been in a privileged position to consider developments in intermediary liability, recent developments. So what I'm trying to do is to assess the consistency of those developments with the intermediary liability principle, at least with two of them. And I'll try to be as brief as possible. I'm going to look into principle number 1 and principle number 2. So whether we intermediaries should be shielded from liability from third-party content and what has been happening in terms of development, and especially in terms of proactive monitoring obligation. And then whether we should have or not, or whether we are having more or less judicial review for intermediary liability. In fact, looking at the first point, my feelings are mixed. Sure, we have on the side new safe harbors enacted. The market civil is a great example. We have a pending bill in Hong Kong trying to introduce a safe harbor regime as well. But at the same time, in Europe, we have seen a proposal for increasing, and those proposals were mentioned, and maybe then later on we will open a discussion on those. We have the digital single market strategy for Europe, which is planning the introduction of enhanced obligation, especially in terms of introducing a duty of care for intermediaries, and enhance a duty of care that in case for responsibility for enhanced responsibility for dealing with illegal content, such as especially child pornography, terrorist materials, and the content that infringes upon intellectual property right. At the same time, confirming this trend, the German coalition agreement of 2014 has foreseen the possible introduction of enhanced obligation for intermediaries. It is already law, the Spanish copyright reform, which has increased liability of intermediaries, especially introducing a notion of secondary liability for copyright infringement in the Spanish copyright law, and introducing obligation of disclosure of identity of potential infringers, alleged infringers for intermediaries. As far as monitoring obligations are concerned, although we generally have a general principle of no monitoring obligation in Europe, here the trend is concerning as well, and most likely in contrast with what the Manila Principles are telling us. At least in most of the European national cases, though we have a great important exception in the Belen case in Argentina, but we have a number of cases in Europe, starting from the so-called allo streaming decision in France. I won't have time to detail the facts of the cases, but I will just give you names, and then we can discuss it later. Then a couple of the so-called Max Mosley cases, which the allo streaming cases dealing, in fact, with copyright infringement and the listing requested to Google, Yahoo, and Microsoft in France for websites streaming illegal movies. The Max Mosley case are dealing with the privacy infringement, and in both these cases, in fact, the Max Mosley case was decided both in France and in Germany. The court imposed proactive monitoring obligation on search engines. At the same time, in Italy, we had a mixed decision with proactive monitoring decided, at least in one case, and another case which, in fact, is confirming that there is no monitoring obligation. At the same time, we have in Brazil the DAFRA decision, which was in fact decided before the Marco Civil, but has applied a strict liability principle and enforced proactive monitoring. As you may know, we have a very important decision from the European Court of Justice, the Delphi decision, which have in fact adopted a proactive monitoring obligation for intermediaries. The great exception is the Belen decision from the Supreme Court of Argentina, in which the court has in fact said that, that there is no monitoring obligation for companies, and that in fact unless in a number of specific cases notices must be decided by a court rather than directly dealt with by companies. The second important trend, and I'll get through it very fast, is related to the second principle, which in fact would seek for judicial enforcement of any intermediary liability decision. In fact, we really see something else happening right now. We see the emergence of so-called administrative enforcement, and I'll just detail to you all the administrative agencies that are dealing with a miscellaneous array of infringements spanning from copyright infringement to defamation and privacy infringement. We have in Italy the AGCOM, which was empowered, the communication authority, with online copyright, with dealing with online copyright infringement. In Spain, we have the second section of the Copyright Commission, which was empowered with enforcement of online copyright infringement. In Turkey, we have the famous President of Telecommunication and Communication, which was empowered with administrative enforcement of any type of violation of personality and privacy rights. We have in Russia the Roskomnadzor, which is dealing with a vast array of different infringement and can order blocking orders on an administrative basis. We have in South Korea the Korea Communication Commission and the Korea Communication Standards Commission, which are still acting with applying administrative enforcement, so no judicial review for targeting intermediaries and imposing their obligation of blocking or deleting content. In Iran, we have the Supreme Council of Cyberspace and the Committee for Determining Instances of Criminal Web Content. In India, we have the Committee X Rule 7 of the IT rules. And finally, and then in Venezuela, we have the Comisión Nacional de Telecomunicaciones de Venezuela, CONTEL, which is blocking and taking down material on an administrative basis. And finally, in China, we have very recently the National Copyright Administration of China, which wants to implement the same mechanism for copyright enforcement of online copyright infringement as it was applied by the Italian AGCOM and the Spanish Intellectual Property Commission. So I will stop here, then maybe we could discuss, if there is a few minutes, what we could do in order to tackle the problem of extrajudicial application of intermediary liability decision, because this is probably one of the important emerging trends. But according to our mapping of the trends, the developments may be inconsistent with what the Manila principles are asking for. Thank you.
Thank you very much, Giancarlo. We have a hand in the audience, but before we go to questions, I'll just make a note that although we appear to be running out of time, the timer up there shows we have a 90-minute session, although we're supposed to have a 60-minute session. So if anyone would like to stay a few minutes after the hour, we can carry on the discussion, and in that case, we don't have to rush so much. We don't have to take the full 90 minutes, but does anyone mind if we run a little bit late? No? Okay. So in that case, I can hand back. Well, firstly, thank you to Giancarlo for raising some very important issues, and it shows how timely the Manila principles are, in that there are, all of a sudden, it seems, a rash of moves to impose duties of care, proactive monitoring obligations. The Delphi case was handed down. So I think this is absolutely the right time for this initiative. And I would like to hand back, before we open for questions, to Niccolo for his additional remarks.
So on one point I wanted to confirm what Giancarlo said, in the sense that I think we also need to look into extrajudicial mechanisms for enforcement that are increasingly adopted by intermediaries. I mean, the Manila principles don't address this squarely as part of the principles, and if you have very strict principles regarding, for example, the need for a judicial order before the content is removed, the risk is that they're going to switch to a parallel framework, and this is what we see. Can I mention just this, because I think maybe I expressed myself wrongly. You talking about extrajudicial, which is absolutely. I probably made a mistake if I said extrajudicial. I want to refer to extraterritorial application. That's one of the trends that is emerging, and we should tackling and discuss within the Manila Principles. So, but we need both extrajudicial and extraterritorial discussion on extraterritorial application. Okay. Thank you. So going now on the projects that I'm involved in that are related to the Manila Principles. First of all, as we are at the IGF, I should mention I'm one of the coordinators of the Dynamic Coalition on Platform Responsibility, which has as an objective the development of model contractual clauses that different kinds of platforms can adopt to show that they have a responsible behavior towards the protection of the rights of their users. In particular, we started with freedom of expression, due process, and privacy, and we developed a set of recommendations on terms of service and human rights. So this has gone forward a little bit in parallel with another project that we started at the Fundação Getúlio Vargas last October. And this project is called Terms of Service and Human Rights. And we looked into actually how the companies are respecting the rights to privacy, freedom of expression, and due process. So we developed a methodology based on human rights standards, and we score the companies according to the level of the protection that they offer under each of these aspects. And I think that in respect to the Manila Principles, how they relate to this, there are a couple of points that are particularly fitting. So the last one that was also mentioned by Rebecca, who has a similar project, is the one that transparency and accountability must be built into laws and content restriction policies and practices. In particular, there is one of these sub-principles that addresses intermediaries and says that they should publish their content restriction policies online in clear language and accessible formats and keep them updated as they evolve, notifying users of changes when applicable. So here we have, of course, recognized the impact that a change of policy can have on the rights of users, so we require meaningful notice before any significant change is made. And with respect to clarity, we have the policy that whenever the terms of service are either incomplete or unclear, vague, like, for example, they say we may do this or we may not, in that case, this can be interpreted to the detriment of the user. So in the Terms of Service and Human Rights project, we rank the company down. We score them in a negative way when they had this vague type of language. On the Dynamic Coalition Platform Responsibility, the objective is to have these model contractual clauses that are pointing towards specific aspects that need to be clear and transparent, as the Manila Principle suggests. So we direct, in a way, companies to the right parts of the terms of service that need to be clear. And the last principle that I want to mention is principle number 4. Laws and content restriction orders and practices must comply with the test of necessity and proportionality. Here we have developed in the dynamic coalition platform responsibility a specific notion of legitimate law, which is a bit of a creative invention to refer to situation where maybe the law is not perfectly consistent at the national level with the international human rights standard. And this can happen from a substantive perspective when the law, requires the intermediaries to reach too much, to restrict too much. For example, the whole YouTube channel when only one video is infringing. And so this was a way in which we incorporated these Manila principles, I thought. And then with regard to the fact that any restriction of content should be limited to the specific content at issue, also again, we recommended the recommendation on terms of service and human rights that any restriction of content that is permanent should only be adopted as last resort. So at the first level, the intermediary, if it is required to remove content, it should not completely erase it from the system, but at least wait until the decision is finalized, it has undergone judicial review, or the time for accessing judicial review is terminated. So, thank you.
Thank you very much. The timer does now say we have 15 seconds left. However, my colleague Jody has gone to the back and confirmed we can overrun by a little bit, but there is another session coming later, so we'll wrap up in the next 10 to 15 minutes. It's great to hear about these other endeavours that are aligned with the Manila Principles, and I should note that if you are doing any work on intermediary liability issues and you don't already have a platform for publishing that, please do consider the Manila Principles website as a possible platform, because we're very open to discussing with you hosting other material there. So let's open it for questions. I saw a couple of hands before. I think we have a microphone here. If you could come to the front to give your question. Second will be Pranesh, and then the gentleman who's coming forward now. So those are the first three. So why don't you line up, and thank you.
Hi, it's not exactly a question. I'm from Argentina. I'm a colleague, not because I work in the same place, but I work in Asociación por los Derechos Civiles. My name is Valeria Milanés, and I a colleague from Eduardo Bertoni. So maybe I can share with you what is happening in Argentina regarding to Manila Principles. We had, like Giancarlo said, the precedent in court, Rodriguez Belén, which was a very important one, but we don't have still law. But we are speaking about Manila Principles in Congress, in academic environment, and Manila Principles are having very good reception in legal environments mostly. So there is a lot of work to do, because we have a very, the legal community is still taking all thinking about responsibility or liability, but we think that we have a chance, because in academic environments, Manila Principles is being taught. So we think it's very good. I just want to share with you that, and I have a meeting at 12, so I say goodbye.
Excellent, thank you. And please, if you can email us some of those details, that would be wonderful. Thank you.
Hi, I'm Bobby Bedi. I'm a film producer from India. My question is a little amateur, I think, because I'm really getting grips on this. But if the Manila Principles require a court order, then in a country like India, it's totally useless, because getting copyright material off the web with a court order is locking the stable door after the sort of horses run away and run away for miles. So how does one tackle it at the legal end over here? I mean, at the moment, we do have some kind of police action, so we can stop sites. But if we were to follow this principle of having a legal order, it would never happen.
Anyone want to respond to that from the steering committee? Or? Okay, let's take some more questions, then we'll make a note to respond to that. So thank you for your question. Sure, you're next in line anyway, Pranesh, so go ahead.
First, a quick response. This is Pranesh Prakash from the Center for Internet and Society in India. And Mr. Bedi was also at, he missed a presentation that I made at the Jawaharlal Nehru University just around 10 days ago, as a matter of fact, unfortunately, where I spoke about court orders and private enforcement of copyright in India and how numerous websites, including goo.gl, which is the Google URL shortener, have actually been blocked due to copyright complaints. And so there's a complete lack of accountability. There are hundreds of websites which, without an iota of proof, without a shred of proof as to their being copyright infringing, have been blocked in India, and including Meta Cafe, Vimeo.com, and others, without a single court order. Now, how would you bring about accountability into a process like this remains a difficult question. And these aren't hypotheticals. This has actually happened, right, in India. Secondly, the question that I have is one about the lack of clarity, and I would love if one of you would take it up, about what is an intermediary here, because there's almost an assumption in this document, in the Manila Principles, that intermediaries are large companies, whereas they needn't actually be large companies. Even individuals, for instance, may be intermediaries. Now, the transparency and accountability framework that is required might actually be quite onerous for individuals, and they might not actually have policies. So how can we shoehorn a one-size-fits-all system towards intermediary liability when there are so many different kinds of intermediaries?
Next question, and then we'll respond.
I'm Danny O'Brien. I'm from the Electronic Frontier Foundation, and this is just a comment rather than a question. I think Rebecca's point earlier that many of you have touched on about removals due to terms of service is an important one. And I just wanted to mention that I think within the next week we'll be launching a site called onlinecensorship.org, which is an attempt to do what Chilling Effects did to highlight government takedowns, where it'll enable people to report the removal of their accounts or content for apparent terms of service violations, and hopefully from that we'll be able to get some data and see if we can introduce or encourage some transparency to this, because I think we're all agreed that it's a bit of a murky environment right now. But thank you.
We'll hold the next two questions. We will get to you, but we'll just answer the questions that we've had first. Also, on onlinecensorship.org, if you go to the website now, you'll see a different website, which is going to be replaced by a brand new sparkly website very soon. So if you're under-impressed by the existing website, don't worry at all. So I think Gabrielle had an answer to one of the first questions.
To the gentleman about how impractical it would be in India to wait for a court order, I think it's important to remember that the Manila Principles aim to set a high standard, and in this sense, we were aiming to have the highest standard possible in terms of the person ultimately, or the body ultimately deciding whether content is unlawful should be a court. So that's why we went with the court nonetheless. I think it's also important to remember in practice that the court order is in relation to the obligation of the intermediary to restrict access to content. In practice, the intermediary would still have its terms and conditions, and that shouldn't prevent the individual from reporting content and hopefully give details as to why he or she thinks that the content is in breach of the terms of service. So there would still be this avenue, but in that particular case, then the approach would be different, since it would be up to the intermediary to decide whether or not there's a breach of their terms and conditions. Now, what we're also advocating for in the Manila Principles is for the intermediary to be as transparent as possible in relation to its terms and conditions, so that individuals know what to expect in terms of what's permissible and what's not on the platform, and to make sure that there are also redress mechanisms, which will lead us into the territory of Pranesh's question about then how practical it is for intermediaries to put in place these mechanisms, but perhaps someone else on the panel wants to respond to that.
Maybe I could. When we were drafting the Manila Principles, we did at the outset consider the different sizes of the intermediaries, and I remember it being said that we even wanted to cover someone who may host an open Wi-Fi hotspot in their house, or have a bulletin board on motorcycles that they run from their bedroom, that sort of thing. But the extent to which the obligations are applicable to different classes of intermediaries is a little hard to discern from the text of the principles themselves. One of the hints you can get is where it says should rather than must. That is where we give ourselves some leeway to apply different obligations to smaller intermediaries than larger intermediaries. So should is really more of a best standard to aim for those intermediaries who have the resources. We have two more questions, so let's take those, and then we'll close off the questions there and turn back to the panel for answers. Thank you.
Okay. Michiel Steltman, Director of the Digital Infrastructure Association in the Netherlands. One question refers to Pranesh's point about the scope of intermediaries again. In the Netherlands, we have some concerns about the broadness of the definitions of intermediaries. In the Netherlands, the Scientific Council for Government Policy has introduced a concept called the public core of the internet, which should be excluded from any interventions anyway for any type of content, including internet exchanges, the routing system, DNS, carriers and ISPs, which means that the communication should be just net neutral, but all other forms of intermediaries, hosting companies, search engines, cloud providers, etc., where the content is hosted, would definitely apply, would definitely be in scope for intermediaries for the Manila Principles. So I'm curious about your vision and position on that, on making differentiation or distinction between types of intermediaries that should be left alone and the ones that are that should adhere to the principles.
Yeah, I'll be brief. Alex Gakuru from Kenya. Probably you said it, but I missed it. But how do you ensure that copyright does not become the tool for censorship, in the sense that abuse of the takedowns on grounds of copyright has become a new tool of enforcing censorship? And what mechanisms are there to ensure that intermediaries are not being made the unsuspecting partners in enforcing that censorship? Thank you.
Thank you. Those are two very good questions. Let's take one last question.
I'm a little person. Thank you very much. I'm Raizu Ribarri from Venezuela, Universidad de los Andes. I want to thank Dr. Frosio for mentioning Venezuela's case. Last year we had more than 1,000 websites blocked by administrative procedures from the regulator entity, which is Conatel. But I want to point out that also our law, our media law, established heavy fines for third parties just for publishing news. That in our case is very worrying. For example, if we are confronting a media landscape hegemony, so people in our country trying to go to the digital sphere to get out our voices. So, for example, we have more than 30 media directors that are being prosecuted because being published in their websites news that were being published in Europe, for example, regarding our authorities. So it's a very concerning issue, this one. Thank you very much.
Thank you. So let's turn back to the panel. Nicola, I believe you have a response to that observation about the different classes of intermediaries.
Yes, in fact, this is a recurring question. So what the gentleman referred to is basically technical intermediaries, and the principle that is usually applicable in this case is the one of mere conduit. So the intermediary is not liable provided that it does not initiate the transmission, it does not select the receiver of contact, and it does not select or modify the information that is transmitted. The joint declaration by the three rapporteurs on freedom of expression in 2011 recommended all regimes of intermediary liability to add this principle enshrined in the law, but it also suggested to broaden this principle beyond mere conduit, mere technical intermediaries. So I think in this respect, the Manila Principles takes a step forward by following that suggestion, and this is something to be praised. On the other hand, it is true that there are different classes of intermediaries who look more in depth into the type of content that is transmitted. And I think also connecting with the previous question about size, we should recognize that the powers and responsibilities of these entities are not the same. So in Europe, for example, we are starting to adopt a more differentiated approach with regard to data protection law. The new General Data Protection Regulation has some higher burdens for data controllers who are have a higher size, higher impact on the rights of users. So in this respect, I think what could be helpful is to look at something that is called the fiduciary duty, that is a theory that is being argued by mainly two scholars, Jack Balkin from Yale and Jonathan Zittrain from Harvard. And it refers to the idea that these entities, you know, they have a duty with regard to the information that we entrust them with. However, the scope of this duty, of course, depends on the expectation that we can set on these different players, and the size and the type of activity that they perform, of course, has a bearing on how broad our expectation can be.
Let's have to wrap up, but just very briefly, I'll go to the panel for the last two questions. There was one on copyright enforcement or censorship through copyright, and one on Venezuela. So go ahead.
Real quickly, only on the other question on the intermediaries, just wanted to highlight what Brazil did as a legal solution. Essentially, if you're an intermediary, no matter what kind, as Pranesh pointed out, you can even be an individual, be considered an intermediary, then the protection of the law applies to you immediately. If you're a commercial enterprise, though, then you have extra duties, for example, on data retention, on trying to figure out who the actual user who posted the content is. So that's the distinction that they drew on the legislation. Not saying it's a good model, just saying it's what exists. On the copyright issue, as my colleague said, essentially, as a practical matter, notice and takedown regimes for copyright are pretty much what's being observed around the world, regardless of the existence of a local DMCA. That's what companies tend to do. And the reason is very simple. Companies are in a very interesting position in which they get pressure from both sides. Essentially, on the idea of private takedowns, what usually happens is we get pressure to be as fast as possible on taking down content from victims of the supposedly online wrongdoing perspective. And on the other hand, we also get the same pressure from the user who actually posted the content. So it's exactly why initiatives like the Manila Principles, who try to influence policy across the world on these ideas, are so welcome, and I thank you guys for all the hard work you've been done.
On that note, thank you very much, everyone, for coming. I am disturbed by the number of laptops that I can see that don't have Manila Principles stickers on them. So you need to get your Manila Principles stickers at the back before you leave. Thanks again, and we'll see you. We'll be in touch. Thanks again.